Lauren, thank you for joining with us. Tell me a little bit, first of all, about what the legal implications of marriage are for couples.
Well, it seems obvious, but obviously you can't marry anybody else once you're married. In some states, obviously you can. In Ireland, you cannot. The family unit is protected by the Constitution in Ireland, so it's considered a moral unit, and as such it is given certain protections in the courts. So thus, families that aren't married versus families that are may have a better source of protection in the courts. Over and above that, only a woman and a man can marry. Under the Constitution, marriage is defined as the union between a man and a woman, whereas same-sex couples can enter into civil partnerships. Apart from that, there are financial implications. For instance, there's no capital acquisitions tax between spouses, and there may be some other tax implications. Obviously, I'm not an expert on those things, so I can't advise on that, but that's something that they should go to a financial advisor for, because those things do change. Then married couples have equal rights with regard to their children. So between people that are not married, for instance an unmarried father, those rights wouldn't necessarily accrue as a matter of fact. They would have to be applied for in court.
So just on that, what kind of rights does an unmarried father have in Ireland to his children?
Effectively, from the time that the child is born, none. Once a couple is married, a child is born automatically with two guardians. So the marital mother and father, notwithstanding the natural father now, for instance, if we were married and I fell pregnant, the child born to the marriage, even if it was somebody else's altogether, would be considered our marital child, and the natural father would be completely alienated. In circumstances where, for instance, you have a non-marital couple altogether, the same applies, and it's not until a father either applies to the court for guardianship or agrees with the mother that he is the guardian of the child that he accrues the right of a guardian. So, for instance, if you have a non-marital couple with the child and the mother dies and the father is not the guardian of that child, then the guardianship of that child could pass to somebody altogether different.
That's quite significant.
It's very significant, and for that reason it's important that if a couple isn't married, that they do draw up some sort of agreement, or that the father applies to the court. But if you're married, it's not a problem. Both parents have equal rights to the child, not just pertaining to guardianship, but in general. So, for instance, if you had a non-marital couple and they fell out, and this happens very frequently, unfortunately, in my line of work, the child is used as a pawn, and it's used to hurt the other person, and mothers frequently retract access to their child, and a father has to go through the whole court process to get access to that child. That doesn't happen to the same extent for marital couples. So, for instance, if the parents split up and the father took the child and kept seisin of the child, the guards wouldn't be banging down their door, whereas if you had a non-marital father and he decided, I'm off with the kids without being a guardian, there are serious implications for that.
And what about when it comes to, say, property? I often work with couples where they're living in their partner's apartment or house and they don't have a will made. What would happen if, God forbid, the partner was to pass away and they're not actually married?
If a partner is not married and the property belongs to the person that has died, then there's no legal entitlement whatsoever to that property at present. With the new Civil Partnership Act, things may change, but at present it's not the case. It will take a substantial number of years for that to be amended in practice. So, on the other hand, if you do die and you are married, the spouse has an automatic legal right share. And if you're married, the house that you live in is what's known as a family home if you own it. So not only does it provide you with protection when one of the spouses dies, it also means that the house cannot be sold from under you. You have to get the consent of both spouses to sell that house on, or alienate any sort of interest, for instance a mortgage, to a third party. So those protections are granted on property.
So what would happen, for example, then if somebody did pass away? I mean, would the person who's left behind in the house, who's unmarried, would they not have rights to their partner's house? Would they go to their family? How does it work?
Presently in law, it depends on if there's no will left, then the property may very well pass to the person who's passed away's parents or siblings. And if a will has been left and they've been excluded, well, then there's absolutely no recourse whatsoever.
And have you found that happens?
It does happen. Ordinarily in modern day society, if you're living with a partner in a property, there tends to be equal contribution to the mortgage, for instance, in which case there is an equitable right to stay in the property. But if you've made no, say for instance you're a stay-at-home mum and you're unmarried, you've been contributing in the home but not paying the mortgage and you're unmarried, then there's no recognition given to that. Whereas if you're a married mother, there is under the Constitution, again, recognition given to the work done in the home. So, say again, if we were married and I raised the children and we got divorced or you passed away, there would be recognition of the fact that I'd contributed to the marriage and to the children by staying at home. It isn't considered to be a nil balance. It's just because I haven't put money in, it doesn't really matter.
And for couples who, you know, where the marriage doesn't work out, and like myself and yourself, we probably work in the same field in that regard, because we often see couples where the marriage doesn't work out. Getting separated or getting divorced in Ireland, what's the process? Not to, you know, we obviously hope that nobody ever needs to who's watching this programme, but what would they need to do that, to separate, or how does it work?
Well, sadly, as you said, people come to us in times of difficulty rather than in times of happiness. And separation and divorce are two very distinct and separate processes in Ireland. So legal separation in Ireland can be done in one of two ways: by way of judicial separation or by way of separation agreement. A judicial separation is when you go before the court for them to decide essentially what's going to happen to your assets, or you can consent to a judicial separation and have that made a rule of court. The alternative is to draw up a legal agreement called a separation agreement, which will tell you exactly what you're going to do with your assets and how you're going to deal with them. Now, you obviously have to be separated before you get divorced, but separation doesn't have to be formal. It doesn't have to be a judicial separation or a separation agreement. For instance, a couple can live in the same house and be separated. They can live in separate bedrooms. However, if you're sleeping in the same bed, if you're sharing meals, if you're going on holiday, the court is not going to be satisfied that you're separated. And you have to be separated for 4 out of the preceding 5 years to be eligible for a divorce.
Okay. Is separation or divorce expensive in Ireland?
It's very expensive. It doesn't have to be expensive though, and it does depend on the couples. As I said, the separation and divorce are two different processes. So once you've been separated for 4 out of 5 years, you can apply to the court for a divorce. And I always say to my clients, if you can work it out and come to some sort of amicable agreement, that is definitely the way to go. It's going to cost you a lot less money because we can litigate from here to kingdom come. We can spend years trying to get a divorce settlement. But if the parties agree, it can be done within a couple of months after the time and the requisite time has elapsed.
Sure.
So one thing that is very important, though, when you do go to a solicitor is to remember that they are legally obliged to advise you on alternative forms of dispute resolution before they institute proceedings. And I very much encourage that, mediation, for example, and drawing up some sort of agreement. Because if you go before a court with an agreement and say to the court, listen, this is what we've decided, could you please make this a rule of court? It's going to cost you maybe 2,000 or 3,000 euros in present day times.
Okay. If
you're going to fight about it, it can cost you hundreds of thousands of euros.
Really?
And to be quite frank, absolutely.
Okay.
To be quite frank, people don't have that sort of money anymore. And
sure.
in the boom times, people did. They went to the High Court. They would fight over all the properties that were there. Now, because they don't have the money, it's just not worth it. And often, once the lawyers are paid, there's actually nothing left for the couple or for the children, which seems ludicrous.
It seems bizarre, doesn't it?
But it's their own fault. It's
sure.
their own fault because they will not agree, and people use money and children as a source of power.
Sure.
Which is very harmful.
I hear what you're saying to me about marriage breakdown and stuff, and I'm very conscious as well that the church values marriage, and marriage is a sacrament, and marriage is something that the church values and keeps sacred, so therefore divorce isn't an option for many couples. But when couples experience a marriage breakdown, what advice do you give them? Do you recommend that they go and get divorced, or do you recommend they go and see a counsellor, or what do you say in real terms?
Absolutely. I would never recommend divorce, even though it's my business. I would first of all recommend mediation or couples therapy, because there's actually very little that can't be fixed by way of proper commitment to the problem. And many people that come into my office will be in, for instance, I had a client that came in last year. He came back this year and he said, well, things still aren't working. I said, will you try one more time, go back to the mediator, go back to the couples therapist, see how you get on. And if after a couple of years it really isn't working, and I've advised them in my legal capacity to take the mediation and the alternative route, and they still don't think it's working, then I can advise them on a divorce. But it certainly wouldn't be my first choice, because the fallout from a divorce is fundamental. It's really very psychologically damaging. Okay, so and I'd be aware of that too. The psychological damage of divorce can be quite substantial. And I just want to finish off on one last question. It's about guardianship and fathers. Do you think that more unmarried men would want or choose to get married if they were aware of their lack of rights to their own children because they're not married? I think that they would. Now, obviously, it depends on the man's attitude to his child.
Sure.
And historically, men have been somewhat less interested in their children than mothers, and although that is a very sexist comment, and it's just my experience that it tends to be the case. But I think what a lot of men with children don't realise is that if they don't have guardianship and only the mother has guardianship of the child, she can do a number of things without his permission. One of them is apply for a passport. Second is, with that passport, she can remove the child from the jurisdiction and remove him from the control of their father forever. The other thing that she can do is consent for medical treatment to the child. So, God forbid, some sort of cosmetic procedure that a father would be very unhappy with. And she can make general decisions on the welfare and education of the child without any sort of input whatsoever from the father. And I think if fathers that really wanted to be involved in their children's lives knew that, they would think twice before deciding, well, I don't really care if the child is married or not, a marital child or not. But one thing that should be noted is that a child can be subsequently legitimised by the marriage of its parents. So, for instance, if we had a child now, being unmarried, and then we decided to get married at a later stage, we can actually re-register the birth such that the child becomes legitimate. So that is something for fathers to bear in mind.
Okay.
Just because they're not married when the child is born does not make it too late.
Okay, great stuff. Lauren, thank you so much for all your wisdom and your experience, and your information has been most useful. Thank you so much.